Okay, so we are now going to discuss, we will now begin with section 13, as we have already finished discussing section 12, no? We started discussing section 13 during our class last Tuesday, no? Section 13, of course, is the right to bail, and it is important for us to look at the words, no, of the provision itself. Under section 13, it says, all persons except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall be, before conviction, bailable by sufficient sureties. So the right to bail is available, right? If you are charged with offenses punishable by lower than reclusion perpetua. But if you are charged with an offense punishable by reclusion perpetua, you can still avail of the right to bail if the evidence against you is not strong. Okay, so and then it goes on to say that the right to bail uh, shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. Okay, so when is the bail required? As we already learned before, no? In the case Seras versus Tiangki, this was the case where she was arrested. She's been detained for several months already, and yet no charges were filed against her. This was before the People's Court, no? This People's Court, of course, is the court then that was trying alleged traitors to the country during the war, right? So she was arrested, detained, but there was no charges. No charges were filed against her, and so she filed a petition. In that petition, she had alternative prayers, no? Either release me immediately or that I be allowed to post bail. She was basically invoking her right to be free, no? But it was denied by the People's Court, so she brought it before the Supreme Court. And the Supreme Court here said that even if there is no charge, no, against you, if you are in the custody of the law, then sorry, may virus ako makalat sa office eh. Okay. Even if you are not charged, no, if you are in the custody of the law, then you have the right to bail. Okay. In Paderanga versus CA, no, this involves a lawyer who was charged with multiple murder. Okay. He has not been arrested yet. But before he could be arrested, he filed a motion in court to be admitted to bail, right? Of course, the prosecution objected, no? But during the hearing on the motion, the lawyer of Paderanga, the accused, informed the court that he was in the hospital, no? Alam niyo naman dito sa Pilipinas, pag mayaman, no, every time charge with an offense, nagkakasakit, nagkakaroon ng neck brace, no? Kakaroon ng wheelchair. So the counsel claimed that he was in the hospital. So the prosecution objected. So he filed a motion to be admitted to bail. Prosecution objected, no, on the ground that he was not yet in the custody of the law. So sabi ng prosecution, he has not even been arrested. The court has no jurisdiction over his person, so the court cannot grant bail. No, so is the prosecution correct? Unfortunately, the Supreme Court said no, he was not correct, because according to the Supreme Court, Paderanga already submitted himself to the custody by filing a motion and by furnishing the court of information as to his whereabouts and by recognizing the authority of the court. So sabi ng Supreme Court in this case, he already submitted to the jurisdiction of the court, and therefore he is already in the custody of the law, and therefore he is entitled to bail. No? Funny, because if in a later case, in a case involving an NPA commander, which we will be talking about later, the Supreme Court made a distinction between the court having jurisdiction over your person and the court having custody over you. Because if you will look back, no, if we will look back at the provision on bail, Kaya sabi ko magandang importanteng tignan natin yung text, no? But let's just, wait lang. Let's, yan, it says, all persons, except those charged with offense punishable by reclusion perpetua when evidence guilt is strong, shall before conviction be bailable by sufficient sureties, no? It doesn't really say here whether it is you should be in the custody of the law or the court has jurisdiction over your person. Diba? It doesn't say there. Okay. So in the Paderanga case, the Supreme Court said he is already in the custody of the law, therefore he is now entitled to bail. Okay? And I say it's funny because in a later case, kasi Paderanga is a lawyer, mayaman, and all of that. Pero in a case involving an alleged NPA commander, the Supreme Court distinguished between being in the custody of the law and the court having jurisdiction over the person. But in a different context, the court then was talking about whether or not the accused then waived his right to bail. We will talk about that later. No? But here, the Supreme Court said he was already in the custody of the law, despite the fact that there is no actual physical custody. He was not detained. He has not been arrested. But because he already submitted to the jurisdiction of the court has already acquired jurisdiction over his person, Supreme Court said he is already in the custody of the law and therefore entitled to bail. In Government of Hong Kong, this is an assigned case. We talked about this already, where the Supreme Court said that, well, it reversed its earlier ruling in U.S. versus Purunganan. In U.S. versus Purunganan, the argument was that an extradition proceeding is not a criminal case. And Supreme Court said the right to bail is a right available if you are facing a criminal case, if you are in the custody of the law because of a criminal case. But in Government of Hong Kong versus Olalia, the Supreme Court said, we could easily apply the ruling in U.S. versus Purunganan, but it is time to review that ruling. No? Sabi ng Supreme Court, well, it's true. This is not a criminal proceeding and bail is supposed to be available only in a criminal proceeding. But, sabi ng Supreme Court, there is a more important consideration, and that is our commitment to human rights. Sabi ng Supreme Court, if we can allow bail in deportation proceedings, and deportation proceedings are also not criminal in nature, then there is no reason why we should not allow bail in extradition proceedings. Okay? So this is the rule now. So even if it is not a criminal proceeding, the Supreme Court said it is also available no, so that you can gain temporary liberty pending the extradition proceedings. Okay? Now, whenever the court grants bail, it has the discretion to impose conditions because, as we already mentioned before, bail is a guarantee that the accused will appear before the court whenever required by criminal procedure or by the judge himself. So whenever the person is required, he guarantees that he will appear. That's why you post bail. So if you do not appear when required to do so upon proper notice, then you will forfeit your bail. Okay? So to ensure that, the court may impose certain conditions. And if you violate the conditions, then pwedeng ma-forfeit yung bail mo. Like in the case of Mangudatu. Okay? In the case of Mangudatu, they posted bail, nag-expire yung bail bond nila, hindi nila ni-renew. But worst, the worst violation is that they were required to attend the promulgation of judgment. They were properly notified of promulgation, and during promulgation, they did not appear. So promulgation was done in absentia, and they were convicted. So they were convicted, but they are out on bail. So the court ordered their arrest, and still they did not appear. The bondsman could not account for their whereabouts. Now, pending appeal before the Court of Appeals, they again wanted to be granted bail. but it is already on appeal. Bail is a right only prior to conviction. So on appeal, it is under the discretion of the court whether or not to allow you to post bail and gain temporary liberty. But in this case, the Supreme Court said the fact that they already previously violated the condition of a previous bail before the trial court is proof that they do not deserve to be trusted again. So the Supreme Court said na it is not correct to grant bail because they have already violated the previous conditions of their previous bail. Therefore, they shouldn't be entitled to bail anymore. In Lavides versus CA, we already discussed this. You already know the facts. This is the accused, if you have forgotten, na mahilig sa Daisy, arrested and charged with several counts, and he wanted to post bail. And the court, said, okay, I will grant you bail, but I will only approve your bail bond after your arraignment. Okay? And so here, the Supreme Court said, as we have discussed in our last meeting, that the court's condition cannot be allowed because it makes the accused, it forces the accused to choose between two constitutionally guaranteed rights. The right to bail on the one hand, and the right to be informed of the nature and cause of accusation against him. As I explained last meeting, the time to move for the quashal of an information because it is defective, because it does not properly advise you of the nature and cause of accusation against you, is before arraignment. After arraignment, you can no longer move to quash. But because the judge condition was magpa-arraign ka muna, then if he will abide by that condition, then he will be forced to waive his right to question the sufficiency of the information, which is why the Supreme Court said that is an illegal condition. That cannot be done. You cannot make the accused abandon one constitutional right so that he can avail of another.